Hi, everyone. Thanks for the opportunity to share our knowledge or our experience working with Oxford academic that been applying for various NIHR funding. So my name is Janice Ng. I'm one of the licensing and venture manager at Oxford University Innovation, the tech transfer office for Oxford University. Right. Yeah, as Sophie mentioned, some of the IP question has been reinserted into some of the NIHR grant applications. So I think with Sophie's help, here are like a list of research program that might be relevant. And the talks that I'm going to present in the rest 29 minutes might be, hopefully will be helpful for you to have a better understanding about IP rights, and the importance of, having early conversations with your tech transfer office if you have one, or if not, colleagues that within the institutions that able to help you to, work out the questions that address the IP sections in the NIHR applications. So here are two sort of like useful link I've included in the deck. So why does the NIHR care about IP and IP rights, and also the management of the IP that they funded through the research studies? So first off, just think about, intellectual property, what is actually it means. So intellectual, think of it as this like a creative product of mind. In the next couple of slides, later on I'll explain or show examples of what are these products actually like in NIHR, funded projects looks like. And this product actually will have commercial value, not, of course, primarily delivering impact, but along the way it needs to be sustainable, and to reach the end users, it needs to have some commercial value and can be bought, sold, or rented, like a house or car. And all this intellectual property generated, you will have rights. So who owns the rights? And if you require certain rights and access to further develop it or commercialize it, how can you gain those rights? And these are supported by a legal framework that exists throughout the world to protect, the creators and the sellers and, the renters of this intellectual property. So essentially, it's everything just really to ensure that the NIHR funded projects that generated the IP can be, can deliver impact in health and well-being. And it's very important for the funders to understand, while you write your proposal, you are aware of, what are the IPs there, what are the barriers out there, have you got freedom to operate to actually further use these intellectual properties? And if you're not able to gain access, how to avoid these IP barriers so that you can think around, design around your research to move forward, progress your research. So in terms of navigating or avoiding IP barriers, some of the questions, you may ask when you are writing your proposal is, think about, are there any issues in securing permission? If, let's say, that's a data that you need to have access to incorporate into your analysis, the materials that you use. If you are in life science clinical research, the samples that you're going to use, the animal samples or the human tissues or clinical data you're going to use. And what are the steps required to secure, this rights, this freedom for you to perform the research? If a license is required, is it possible to license the technology or the data, the materials in the subject area? And with funding, you are actually essentially creating more value to the intellectual property of your research, of the technology or the idea that you propose. And in the NIHR application, it's very important for you to be able to clearly identify the ownership of the invention, of the research output, able to defend the technology against anyone that will be copying your ideas. So that's why at beginning of my presentation, I mentioned, have early conversation with your tech transfer office or colleagues able to support this. And provides an explicit tradable commodity, for example, patent strategy, making sure if you decide to file a patent to protect your intellectual property, engage a certified patent firm, patent attorney to actually write the patent. I know sometimes people may want to write their own patent application. They are really legal wordings that is very essential when later on you want to defend your freedom to operate, or when people infringing your idea, those very specific legal wordings very important. So they are not like just scientific writing. And of course, if you find a strategy to protect your rights of the intellectual property that you created, it just makes the technology to be more attractive to commercial partners. If your research output essentially is, to commercialize it, either to finding an established company or a pharmaceutical company or biotech company to take on the technology to further develop it, for example, a medical device, then they'll be asking question about what are the IP protection that you have for your invention. And equally, if you plan to create a business venture, an entity, or maybe a social venture to serve the target community that you like to deliver impact to using your research output, you would like to make sure that the idea is being protected, and so that you can receive the necessary fundings and investment into the business venture. So essentially is to increasing the chance of achieving patient and public benefit. So there are many different forms of intellectual property, and how can we protect them? So those are the rights. So this I refer to the products that earlier on in my first or second slides. So it's a busy table here, but I'll go through line by line. So first off is patents. So not all intellectual property able to be protected by patents, because it needs to address 4 factors. So first, it has to be a new invention. The idea is novel, it's inventive, supported with data on the claims on the invention that you try to protect through this patent application. It needs to be applicable. That's actually a need out there. That's a market need and an end user need out there. And whatever you spell out, you detailed in the patent application document, it needs to be enabling, allow people to actually able to reproduce it. So in return, what you get is 20 years of rights. Basically, whoever that wants to use your patent or the inventions or the informations that tell in your patents, they need to get a license from you, and you'll be protected for 20 years and additional 5 years for some medical applications. So how you attain this is through an application with various jurisdictions of IP Patent Office, and it's through examinations depending on which jurisdiction you would like the patent to be validated and granted. You go through examination in that local jurisdiction. Typically, it would take 5 to 7 years to get a patent to be granted, and that's the process. And next is copyright. Many of you probably have heard about this. Copyright in terms of writings, of songs or images. So it's the original creative and artistic forms that you can have copyright on. So in addition to the songs or images that you are quite aware or come across, web content also can be copyrighted, recordings, software, soft code, and object code, and also questionnaires that you develop during your research studies, or questionnaires that you will be used in the clinical trials that you want to collect patient reporting outcomes. So those can be copyrighted. So these will be protected automatically. It exists automatically, and it's for life plus 70 years. And there's database rights. If this one protects against copying of the database, not the data. So it has to be original collation. And it also exists automatically, and it has a protection of 15 years from the creation of the database. So it could be a collection database of information that you gathered from your research output that you have curated and you specify, what is actually used in the application of that database. And if, let's say, an entity is keen to have access to that database in order for them to gain more value for their product or services, then, they will require a license, a database right license to use that. And trademark. So this is really not for many applications, but for some of the applications where you are actually looking to creating products and also creating a brand for yourself. So trademarking could be important. So this gives the identification of the products and services. So you will require a registration and it is indefinitely until it is not used for a period of 5 years. And there's design rights as well. So think of design of, a certain like iPhone, the design, or certain product design, the friendly user interface design. So it's really to protect the external appearances. So this also exists automatically. But in some legislation, you require prior registration. So it's a protection of maximums of up to 25 years. And finally, that's trade secret. So I always get this question of, how do you protect trade secrets? Basically, or protect know-how, basically is not to disclose it to anyone. So this probably is against some of the aspiration and that, that research output needs to be disseminated to deliver impact. However, for certain projects, especially in the pharmaceuticals or very specific niche project where, you can file patent on to protect, then the information will be publicly available after 18 months. And then with publication, however, there will be some certain elements that, if you have commercial entity that is keen to keep it as a know-how, as trade secret, then there will be a discussion of not to publish it. So how do you protect this is by employee contract, confidentiality agreements, and you build firewalls around, how not to share the information across team. So think about the formulation of Coca-Cola. I think it's quite famously known. So it is protected until it is no longer a secret, and the value diminished because then it's not considered a trade secret anymore. So here's just a quick exercise. I'm not sure whether the chat is open. So I've listed a few intellectual property examples here, and what would be the protection strategy for this intellectual property listed. So for example, local new guidelines, improved checklists or questionnaires. I think based on what I just explained in my previous slide, it can be protected by copyright. New clinical data can be protected by database rights. If I move on to the next slide, freedom to operate. So this it's not very often an NIHR IP question asks about freedom to operate, but there are some of the applications do ask about freedom to operate. And essentially freedom to operate is the freedom for you to able to perform your research and also commercialize your technology and idea without infringing the intellectual property rights of the others. So just make it a bit more context. So let's think about right now, I'm writing a grant application and I'm trying to fund, my future research. and this will give rise to arising IP. And in the application, you will need to list a list of what would be this arising IP look like. And then you'll need to, at the back, think about what are the background IP required you to support your research that you're going to propose. So those are, but in terminology, will be considered as background IP. So for arising IP, I mentioned, it could be, during the course of the project, you may be generating new patient data, new samples. If you're using NHS or university resources, what are the terms and conditions with regards to the IP rights on this arising IP that you generated? And if your proposal actually involves collaboration with third party, with another research institution or with a commercial industry collaborator, or is it a pay for or fee service contractors? So please make sure that you understand the arising IP that generated from this collaboration, who owns what, because you will need to detail them in your application. Also consider some legal ownership and rights to samples, data, and materials. I've talked about patient data. How about blood samples, medical scans, animal models that you're going to use? Do you have actually rights to use them? The antibodies that you're going to use in your research, the cell lines. Do you require consent actually? Especially if in the long term, you plan to commercialize the research output. So you need to make sure that, you have consent to actually use this for commercial purposes, because some of these are actually maybe only provided for non-commercial purposes. And with regards to background IP, so have a think about in your past research, you have generated all this data for you to propose your future research. What have you discussed with the previous collaborators, or any terms and conditions from the funders? If you come from a previous institution and now you are in a different institution to moving forward with the same or similar research proposal, then you may need to go back to your previous institution to make sure you have the right to actually continue with those research. And also, actually, for your future research, are you still relying on that third-party IP because you have used those in your past research, especially on software, and also some of the library packages that you use in your past research? So then finally, towards commercialization, there will be, existing of other patents that may cover your invention. So in order for me to explain this further, I mentioned about patents in my slides with the table with a long list of intellectual property, types of intellectual property. So here is an example to explain what does freedom to operate from a commercial point of view. So if you plan to commercialize your research output, and this example here is a biosensor, at the end of the funding application, you file a patent on this biosensor, and this biosensor enables non-invasive accurate measurement of blood glucose through sweat, and it's suitable for mobile devices like smartwatch, wristband, and etc. And you have this patent filed, for example, in 2024. So you have a patent. Many academics would think, well, I have this patent now. I can just, create a spin out and then start creating, incorporating these biosensors into a smartwatch that I can contract a manufacturer to develop for me, or a wristband, and then I can start selling it. Well, actually, no. So if you look at the patent landscape, and this is a quick search I've done, it's a bit dated, but it's sort of like give you a perspective of actually out there are a lot of patent application that being filed in non-invasive blood glucose sensor sectors. You can see the in blue is the numbers of new application being filed year on year, and in green is those that's gone through examination and being granted. So, and if you have a deeper look, you can see there's lots of all these patent owners are working a similar concept. Companies like Dexcomic, Zoli Medical Corporation, Samsung, Medtronics, all these companies work within this field. So do you have freedom to operate? Entirely, probably not, because you only got one patent very specifically for your invention for that biosensor. So, my advice is to talk to your tax transfer office that supports your spin-out creation, and then get legal advice from patent attorney that actually able to perform freedom to operate analysis search for you, looking at all these patents that actually mean that if you were to manufacture and sell these devices, would any of this would your product actually be infringing the patent that filed from by these companies? So I have another exercise here to elaborate, to discuss more about freedom to operate from the research perspective and a little bit on the commercial perspective. So this exercise is hopefully can give you a sense on how do you identify intellectual property rights, what are the possible freedom to operate challenges, and how to gain arrangement to gain intellectual property rights and freedom to operate. It's a fixations case, and it's quite a complicated one because I thought to give the worst case scenario, but I probably most of the time it's not that complicated. So the example here is the closed loop artificial pancreas for type 1 diabetics. It has a bit of elements of technology, of software as well. So the background IP here is part of the software was downloaded from an MIT website, and the insulin microdriver was taken out from an old Medtronic pump. So in the lab, you have developed a proof of concept device, and you just take disassemble Medtronic pump and then put the insulin to use the insulin microdriver. And using this, proof of concept closed loop artificial pancreas, you received some funding to run some clinical trial. The funding is funded by MRC, and it's in collaboration with a commercial collaborator who presumably is quite keen on this technology. So moving forward, you decided to apply an NIHR funding to progress further. And then you plan to work with Johnson & Johnson to build an improved user interface on the closed loop artificial pancreas. And you through in a conference, you met someone that has affiliation with Harvard University that has great expertise in software, in writing algorithms, and you hope to have collaboration with this professor from Harvard. And because you plan to run more clinical trials, and then you found that from Cambridge University that someone actually developed a patient-reported outcome measures that is very relevant for your proposed clinical trial for you to report the outcome. So you would like to use that in your clinical trial. And the brand currently you are thinking about Oxford Artificial Pancreas. And early stage commercialization issues identified is, there's another company called BioBeta Medtronics filed a patent that, covering similar type of the system in 2000. And then the insulin pump, unfortunately, can only work with Abbott Freestyle GB monitor. So I can see it's really, really complex here. So what's the rights here? What's the challenges here? What's the barriers here? So if I were to go forward this NIHR application, so first off, looking at the software, have a think about the software. Is it an open source, permissive, a copyleft license still required? A conversation with the tax transfer office from MIT for you to get a license to use that in your further development. And with the insulin microdriver, is there a patent? Is this patent still active? because it says really old Medtronic dump, because if the patent has expired, then maybe you are okay. And the clinical trials, auto funded by MRC, what's the agreement between this commercial collaborator, who owns the clinical trial data, who has rights to actually continue the clinical development of this project. And with the arising IP, you plan to work with Johnson & Johnson. Well, have a conversation with Johnson & Johnson as well. What would be the IP ownership look like? Is it going to be a joint ownership? Or is it going to be owned by university where Johnson & Johnson will have some sort of rights to actually use it in the future as well? And with your collaboration with Harvard, specify in the application what type of collaboration as well. Again, the IP ownership, is it going to be a joint ownership, and what arrangement has been discussed? The patient reporting outcome measure report from Cambridge. Have you spoken with Cambridge Enterprise, the tech transfer office, to gain access to actually use this? What are the rights if you want to commercialize this and continue to use this? Will you be able to license this from Cambridge Enterprise to use this further on? And with your brand, have a check on the trademark. Has anyone else used this name? With the commercialization issue, what are the claims? BioBeta Medtronics has filed a similar type of system in year 2000. Would this claim actually be overlapped with your invention? If it does, have a chat with your tech transfer office. What's the way to invent around? Or maybe actually in the future, if you plan to commercialize it, can we actually get a license from BioBeta Tronics? If we can't, is it feasible to have the license right now so that we already got freedom to operate to commercialize it later on? And use of insulin pump, maybe you want to use a different pump because you want to use a different monitor, or if not, then you have to use the Abbott monitor. So just in summary, this will be my last slide. I would say don't let your IP section be a last minute or an afterthought after you have write your whole application. Have early discussion with your tech transfer office. It is very important in your application to show that you have identified, the necessary resources of who, how, and what to manage the background and arising IP, and also what would be the commercial exploitation strategy. And if you plan to commercialize it, what thoughts have you put into the plan in order for you to gain all this freedom to operate licenses? So yes, the application is really to demonstrate that you have thought ahead and all the way to getting your technology into the hands of the clinicians and the patients. So be very clear on the IP strategy, and if relevant, talk to your tech transfer office to whether you want to protect your IP before any publication, and seek advice early.